If you're going to use the 4-year rule, make sure you have all of your information up front and just prove without doubt to the council that what you're saying is true, because it's really, really important. Otherwise, like I said, you're going to get in hot water. When people make alterations to their house or changes of use to residential or any other alterations, they look to the 4-year rule to rectify the situation from a planning point of view. It's a well-used way of rectifying changes to your house that you haven't already got planning permission for. So this video is going to walk through the 4-year rule, explain what it is, and then go through best bits of evidence that you can submit to make sure that when you approach the council looking to use the 4-year rule, then you've got the best information possible. So I've been a planning officer in my career, and I've seen the 4-year rule used over and over again, and I've seen people make big mistakes with it, and I've also seen people that have just sailed through. So what is the 4-year rule? The 4-year rule is an area of planning where if you make changes to a house, or if you change the use of anything to residential, then you benefit from what's called the 4-year rule, which is a way of you demonstrating to the council that what you've done to your property or the change of use that you've made was done without doubt more than 4 years ago. So the key to all of this, though, is that when you use the 4-year rule, the onus is on the applicant. So if you're approaching the council, then every bit of evidence is on you to provide. If you provide evidence and the council finds something to the contrary, then you could be refused. So you want to basically cover every single area that could possibly be used to demonstrate that what you're saying is true, and this video is going to walk you through that. So now let's walk through each bit of evidence that you can submit to make sure that your application using the 4-year rule just sails through with no problem. The first and most important piece of information or evidence is a statutory declaration, and this is essentially a statement from you asserting that something's true, and more often than not they're signed in the presence of a solicitor to formalise them. Now these can be declarations on behalf of you, but also from other people that are relevant to the application you're making. So as an applicant, you can say, I believe that my rear extension was built more than 4 years ago, or my change of use happened to residential more than 4 years ago, and you sign it you believe it to be true. Then in all the other evidence that we're going to talk about later, you can have a statutory declaration from each of those people. So if you've appointed a contractor, you can ask them to write a quick statement to say, I was appointed on this date, I started work on this date, I completed work on this date, and then it needs to then match up with the evidence you submit, again signed by a solicitor. And then if you're doing things like change of use to residential, let's say if you divided a house up into flats but never got permission for it, you will need statutory declarations, or you don't have to, but it was very helpful to have statutory declarations from each of the tenants, which is key to showing a kind of more than 4-year period. So if you did the works 5 years ago, they were completed, and then you started letting them out, it's very compelling evidence for you to have a statutory declaration from each of those tenants, which is then supported later on by the contracts that they signed, which would allow them to stay there. So statutory declarations are a really important first piece of information, and they're kind of the front runner, which is then backed up by all the other information that we're going to talk about next. The second bit of evidence is plans and evidence of completion of the work. So this is true of changes of use and extensions. So if you've made alterations to your house, let's say a rear extension, then obviously you need to submit plans to show that to be true. So plans that are accurate, so that if anyone does a site visit, they stand up to what you're showing. And then the key bit, because obviously we're talking about the 4-year rule here, so the key bit is to demonstrate any evidence of that work taking place, and any dated evidence that you have that supports that. So the key bit to this is things like before and after photos, and dated, so that's just one piece. But then also any contractor that you've appointed for the work, you'll need emails to show when they're appointed, when did they start, and then a kind of signed agreement between you and the contractor that's dated to say that more than 4 years ago we started work on this and we were appointed to do this work. Then you can do photos during the works to show how it was going on and how it eventually meets up with what you're what you're applying for then. And then a very important piece is a certificate of completion from basically when the contractor hands it back over to you. So you need something signed that confirms what has been done and when it was finished, and then that stacks up with the photos you have and adds on to your statutory declaration. So there you have one really good piece of evidence. Next bit of information, and this is really kind of most useful for when you're demonstrating that something has been changed to residential, not so much for extensions. So at the beginning of the video we talked about statutory declarations from each of your tenants to show that you've let the flats or the house for more than 4 years. So it's fine having that declaration, but then you need to back it up with something. And I've spoken about their contracts and their ASTs already, but the other really important information is their utility bills and council tax records. So council tax records are a great start because they are essentially showing, look, we're already registered in your council as having all these flats. So you just go to the council tax records website and it will show what band they're in, and if you can then print off that information or scan that information and put it in with your application, it's very compelling. Again, this all needs to stack up. If anything doesn't match up with what you're saying, then that's a kind of red flag to the officer. So yeah, council tax records, really key. So that shows that this house was divided into 4 flats more than 4 years ago. This is when the council tax records started, and this correlates with when the work was completed and when I let them out. The other one is utility bills, so electric, water and gas bills, showing that this tenant started paying bills with this provider on this date for this long, and then hopefully you should have a clear breakdown that this tenant paid these bills during this contract, and then the next contract, and so on and so forth up until the point that you're applying. So those are really compelling evidence. So if you've got a statutory declaration saying I've let them out for 5 years, these are all the tenants saying that they lived there for more than 5 years, and then if you've got the utility bills to back it up, the tax records to back it up, then that's really compelling evidence. Another piece of information that I've touched on already is the tenancy records. So if all of your tenants have been there for so long, make sure you submit details of each tenancy to the council, which is then obviously backed up by everything I've said already. The other important thing you can add is their voting records. So once someone moves in and they want to vote in a local election, they will have records of that happening. So you can search on the council's website, find that, and again, if this all correlates, then you're in a really strong position. Last one is a mortgage valuation report. So if you divided the house up, or a house or anything up into flats, and you want to prove that you've done that, but if you borrowed money up against it, or if you needed a survey done or anything like that, then a valuation report can be done, and that essentially explains or will explain what the property was when they went to value it. So if the flat was valued for X amount, in their report they will say upper floor flat, I've attended on this date and this is how much it's worth, blah blah blah. So it's just a very compelling piece of information that basically shows that someone went on site 5 years ago, they assessed the property, and they believed it to be what you're applying for. So again, very strong piece of information. And all of these things that we've talked about here are just, if you have all of these in line, then really there's no other way that the council can prove otherwise, because really you've got to prove without doubt that what you're saying is true. And if you cover off every bit of information that I've just listed here, then you're in a really strong position. But because essentially the officer is going to do the same thing. They're going to search for these things, and if they find anything that doesn't show what you're proving, what you're demonstrating, then it's a raise a red flag and you could be refused. Now the important thing to know is that if you're refused, there's no right of appeal. The only way that you can appeal is to the High Court, and that is the only way that works is if you are trying to demonstrate that the council didn't make a decision in line with the legislation. So it's not like you go to the inspectorate and you argue your case like you do with a normal planning application. This is a matter of law if you're appealing that. So this is why it's really key and really important to show from the very first moment that you approach the council that everything you are showing is in place. Don't let the officer find out any otherwise, because if you get refused, do you need to go to the High Court if you want to appeal? You'll probably get served an enforcement notice, and the only way to sort that out is to rectify it from a planning point of view, which means that you may need to apply. Now the issue with that is that a lot of people use the 4-year rule sometimes to show that, yes, I've got flats, but sometimes they're not up to standard if they were applying for planning permission. So if you get an enforcement notice saying that what you've done is unlawful, you need to rectify it, but you won't necessarily get planning permission for what you've got. You'll have to apply for something that may be better, which could cost you a lot of money to rectify. So if you're going to use the 4-year rule, make sure you have all of your information up front, and just prove without doubt to the council that what you're saying is true, because it's really, really important. Otherwise, like I said, you're going to get in hot water, and no one wants that. So that wraps it up, and just for clarity, this was a video about the 4-year rule, which only relates to residential. So you can submit all this evidence for what's called a certificate of lawfulness, and you can do that for all other types of buildings. But for everything else, for all the kind of commercial uses or commercial changes of use, you're talking about 10 years. That's the timeline that you need to demonstrate. So it's a much more onerous application. I can do a video on that as well if you want me to, so just leave a comment in the comments below. But yeah, so this was just about residential, and hopefully this helps you, because if you have all this information up front before going to the council, then you're in a great position, and yeah, hopefully it helps you out. So if there's anything else that I've missed, that sometimes there's lots of other information that you could submit that's really helpful to your case, that kind of goes outside of what I spoke about. So if you have an example of what you submitted for your case, put it in the comments below so that everyone can kind of have a look and benefit. And if there's anything else related to certificate of lawfulness that you want me to do a video on, I'm happy to do that, or just expand on the 4-year rule, I'm happy to do that as well. So leave a comment, like the video for me, and I will see you on the next video.